Hey, g'day, Juanita. Mark
Hello, how are
Westcott
you,
here.
Mark?
Juanita, how are you today?
I'm very well. How are you?
I'm great, thanks. Down in Adelaide today, and you're in Brisbane, so we've got the capital cities covered.
That's it.
Okay, what would you like to talk about today? What topic takes your fancy today?
Well, I believe we're going to talk a little bit today about trying to rule from the grave.
Absolutely. That's an interesting topic because many times when we talk to clients about estate planning, and you talk about testamentary trusts and creating asset protection. Um, Once every now and again, someone says, "Well, that's great, Mark, but I don't want to rule from the grave." And I was talking to someone down here in Adelaide Hills yesterday, and we were talking about creating protection around the assets and so on, and it's interesting. Sometimes the conversation goes on, and the person says, "Well, look, that's great, but how about I just let them do that themselves, after I've gone?" And of course, that's not how it works. As I explained, I said, "You're the only ones that can do it. Once you've gifted something to your children, I mean, that's it. It's out there. It's at risk, and there's a cost, isn't there? Then of anyone transferring any assets into a trust themselves, and they sort of get a free pass, but the penalty is you have to die to be able to do it, I guess."
Yeah, it's a fine line, isn't it? Because we're always talking about putting in place great structures and providing, good asset protection and the right people controlling your estate, etc. But we'll also sometimes see clients that want to, when we say rule from the grave, put in parameters and rules that probably go too far and overstep the mark a little. So that's less about the structure and the trust and the right people in right positions. Uh, then eventually realizing that the adult or the beneficiary is going to have to be responsible at some time to at least manage the inheritance that they've been left.
Look, absolutely, and look, as we all know, you can set up the greatest testamentary trust in the world when someone passes, but I mean, ultimately, at the end of the day, the child can always wind it up, can't they? Against
Yeah,
everyone's
so
best
that's right.
advice.
Yeah, well, that's right. And all trusts must have a vesting date or a termination or an ending date. That's certainly the law. So usually it's as long as possible that we provide for. But you're right. In most wills, there will be an option for the beneficiary to elect not to have a testamentary trust, and it might be a reason such as the estate is a lot smaller than it was when the will was put in place. So the volume of the estate may not warrant a testamentary trust necessarily, or there could be other reasons subject to accounting advice. Why that person might wish to take an inheritance in their own name versus a testamentary trust. So there's certainly those options available there if that's what the client, the deceased person who's putting the will in place want.
Yeah. What are other examples? I mean, we talk about testamentary trusts all the time, so probably the people that are watching this are well aware of the advantages and the reasons why you'd put a testamentary
Yeah.
trust in place. And if they haven't been paying attention, there's plenty of these that we've done before that talk about asset protection and testamentary
Yeah.
trust. What are other ways, Juanita, of where someone tries to rule from the grave? What are other things that people traditionally, because sometimes parents do want to try and rule in some ways from the grave. For example, if they have a child with a drug dependency, an alcohol dependency, an inability to manage money properly, and so on, parents may try and put things in place to, uh, it's a flip between trying to rule from the grave and still just provide some love and protection so that the money doesn't get wasted when it's passed on. So what
Yeah.
other tools can people use?
Well, a couple of examples that pop into my mind of parents or family members trying to rule from the grave. One is around age. So we've often discussed it's not a great idea to have an 18-year-old take their inheritance. It's quite normal for people putting in place their wills to more want an age of 25, 30, around that sort of age group, at least to take their inheritance. But I have seen in some cases people wanting to put a lot longer ages or a lot older ages in place, 40s, 50s, which I think is a little bit crazy. That's certainly too old. At some stage you need to, unless there's a specific circumstance like a medical or mental reason, there is at some stage you need to trust that person to take control of their own inheritance. So it's always an interesting discussion around that age. I've also seen people wanting to leave conditions in their wills. So, such and such will take their inheritance as long as, and, more commonly it's long as they're still married, not married, living here, that sort of thing, or no one else is living here with them. So, that's always an important discussion to have. And obviously respecting the person's wishes, but you just can't go too far, I think, with those sort of things. Indeed, some of those conditions can be so onerous that the law will render them invalid. Another example that pops to mind that there's some good law around is insisting a beneficiary be of a certain religion or remain of a certain religion in order to receive their inheritance. And it's things that probably go to that extent that the law will often, if it was ever to appear before a judge in a court, say that those sort of conditions are unacceptable and do go too far.
Okay. Look, one of the things that sort of springs to mind is, say for example, an older husband and a younger wife. And without being too cliched here, in cases like that, they may leave money to their spouse on the condition they don't remarry, or they don't live, they can only live in the house as long as they're single or haven't taken up with someone else. I mean, are those sort of things, are they still common that people would do that? And if so, are they kind of in the same category as you were just talking about, that they don't really hold water?
Yes, no. Well, no. Sometimes we'll see perhaps like a right to reside in a property for a certain period of time, and that might end if that person that receives that right to reside enters into a new relationship, or leaves town, or that sort of thing. So that's quite a common, I suppose, gift or right to leave behind. I think what a lot of people might be concerned about in the scenario you gave of second marriages perhaps is that their wealth typically passes down the bloodline. And we've spoken about bloodline before, and there's definitely ways you can structure trusts so that's achieved. So you still can provide for the spouse that's left behind, but then also ensure that the bulk of the capital of your inheritance, or of your wealth, does pass down to your children and your bloodline. Because what a lot of people don't understandably want is for them to leave all their wealth to the surviving spouse, then the surviving spouse remarry or enter a new relationship, and then that wealth then goes sideways potentially into a second blended family rather than down through the bloodline. Or if there's another relationship breakdown, it can be subject to family law proceedings. So, quite correctly, people are concerned that their wealth goes down to their children as well. And there's definitely structures we can put in place to assist that without going silly on the sort of...
Sorry, I pressed the wrong button there. My mistake.
That's all right. We're back.
We're back.
I thought you were putting an end to our conversation.
No, sorry. I was just changing the background subtly while no one was watching, and all of a sudden I pressed the video instead of the background. My mistake.
Yes.
You there?
Yep. So that's that's a good example of well, I wouldn't say that's ruling from the grave. I'd say that's putting good asset protection and implementing your estate wishes that your family benefit from your wealth, which is it's fair enough. As opposed to silly conditions of not receiving anything unless you're a certain religion or etc. etc. Yeah.
Yeah, and I mean that does raise a good question, because a lot of times when we talk to people about, and you mentioned things like testamentary trust, asset protect. Well, you're talking about asset protection and putting a circle around the sort of the child and their children, and at the exclusion of the daughter-in-law or the son-in-law, and probably over the years, it's made me realise that it's not that you don't want to look after the son or the daughter-in-law, the son-in-law or daughter-in-law. It's not like you're saying you're throwing them to the wolves if the child, the blood child dies and so on. But it's effectively just putting protection there, isn't it, to make sure that if they remarry, that if the daughter-in-law remarries, then her next husband and his 5 kids don't end up with the the family wealth, so to speak. It always trickles down to the children where appropriate, or if there aren't any children, to other siblings and so on. But no one's ever trying to kick out the daughter-in-law on the street, so to speak.
No, that's exactly right, because especially with a lot of our rural families, that daughter-in-law or son-in-law, it might be the other way around, has really contributed over a long period of time to the business and the farm and the family. So it's certainly something that needs to be balanced and respected. And it's certainly finding that balance between asset protection and bloodline, and making sure that the people left behind are all looked after and are comfortable, basically, and have the ability to carry on living in the position that they are accustomed in doing so.
Yeah, absolutely. It raises just one of the questions I thought I'd ask while you're here is, speaking of ruling from the grave and or not, but sometimes the wishes of mum and dad might be that one of the particular children, sons or daughters, takes over the family farm, so to speak, and that's fine. That's what the intention is. So the farm goes into a trust, a protected area, protected estate, and then the son or daughter has 3 or 4 of their own children, or whatever number. And at some stage, then the issue is the whole farm wealth is in a testamentary trust, and there's 3 or 4 kids sort of beneficiaries of that trust, along with the child of the grandparents, so to speak. How does that trust then get split up at some stage when the next generation comes along? How do you keep, if that's the only asset that family has, how do you create equality or fairness for the next generation coming through?
Yeah, I think it depends what assets are in the trust. So if it's property, or ideally you want to separate your property and your business, your trading entity as such. So there are all sorts of different ways to skin a cat, isn't there? So if it's just a matter of distributions from a trust, then that might be that structure might continue on okay. But as beneficiaries get older and want to go their separate ways, certainly you want to be independent. Sometimes we have wills that are structured so that they can be split in certain circumstances, and there's sort of a cascading effect. You could have certain assets, such as the property, in that trust, but have trading entities or businesses operated by different beneficiaries in another entity, and leasing land off that trust, perhaps. And there's different things like trust cloning that you could use. So there's all different. There's a number of different ways to rectify that, but it's certainly I think important where you're where parents. The perfect example is our rural families, and you want to be considering who's going to be looking after the farm or not, and where you're going to be directing different assets and into different entities or trusts. So I suppose it's an example of why we need to look at everything as a very wholesome picture, and
Yeah.
and not just be too tunnel vision that, you know, A and B get X and Y.
No, that's right. And, you know, certainly in the workshops we ran up in Queensland, Tom and I ran through Queensland, you know, 2 or 3 weeks ago. You know, a lot of instances it came up that most of the family wealth is in the farm. And so you've got all this wealth sort of in the property, the farm, and the farming business, and very little off-farm assets. And I guess that's part of the work I think you know, I've got to help clients with along the way too, is creating you know, what Tom refers to as silos of assets off farm, utilising the value of the farm and taking some of those funds off farm, whether, you know, superannuation is certainly only just one of those options, but might be buying commercial real estate or whatever, so that whilst, you know, you've still got the farm in the protected environment, you might be setting up other family trusts with other assets which have been geared against the value of the assets in the original trust.
That's
So
right.
that way you're creating your 3 separate trusts for your kids along the way.
Yeah, utilising your superannuation. So yeah, exactly right. Sort of separating your farming assets and your non-farming assets. And we can also do things like put in the will. You know, if the only asset was one big property that you didn't want to split, then perhaps that would go to one child with the condition of the will that they repay the other child over a period of time, which is you know, reasonable and affordable for them to do, so that eventually after that period of time the children are, you know, have some equity between them without, you know, without dividing or cutting up that property or leaving one out or making them go into business together, which sometimes isn't a great idea either. That's an example reeling from the grave, when you make your children go into business together, which often they don't want, and ends up into an absolute disaster. So, you know, it's good to sort of consider what the ultimate plan is there too.
Yeah, it's interesting actually, the number of times, you know, in conversation with people, and certainly with the parents, they have this dream of maybe there's megalomania involved. I'm not sure, but they have this dream of this, you know, big estate, and I think it's a want to leave a legacy for the whole family, is that you create a you know, like a master business, and you want all the kids to be involved and everyone to sit back. And, you know, I had someone talk to me the other day about how they wanted to have this big unit trust created, and all the kids and grandkids and so on had units in this unit trust. And I sort of asked the question, I said, yeah, okay, well, who's going to run the property to provide this income stream for all these people just sitting in the background, hanging around waiting for a check? And whilst it's, you know, a lovely idea to have a, you know, a big business that's going to feed the whole family, I mean, the truth is I'm spending a lot of time recently with clients who have been put into that position by their own parents, and what it does, it just creates animosity between the siblings, and you end up with a whole lot of cousins that don't talk to each other again, because, you know, at some stage, you know, while it might have been a great idea while the kids were both 18 and 19 or something, and they went in and they worked their butts off together to build something up, when they get married and have their own children, eventually it just gets to the stage where, you know, it's just never going to work. And, you know, I just try and talk everyone out of it that wants to put their children into a joint family operation, because I think the greatest gift you can give your kids is the independence to go off and do their own thing. And some will fly, and some not so much, but you know, everyone needs their own independence, because they're going to create their own families and their own legacies. And I think you know, it's dangerous to whack people in together. I just want to go back and talk about, you mentioned before, Juanita, some of the times where people do try and rule from the grave, and a court will just look at it and say, well, you know, that's too harsh. And so just some of those examples you talked about, you know, religious beliefs, political beliefs probably, and so on. You know, in your experience, what are the ones that have been the greatest, you know, where the court has just thrown it out and laughed at it? What are those sorts of examples?
Yeah, well, I think the example I gave, you know, around religion is one that's definitely been thrown out. You can't make someone be or stay a certain religion, you know, as a condition. It's just not not accepted. It's not acceptable in society. It's not a societal norm, I guess, that's sufficient. I suppose perhaps another example would be perhaps medical wishes. You can't force medical conditions on someone that they do or don't. Maybe in this time and place, it's getting your COVID vaccine. I'm not sure or not.
I was going to say we can't bring that into it.
I don't think the court would see as an appropriate condition of receiving inheritance. So you can get the flavour.
Yeah. Okay. So and that's kind of how it works. It's like if a reasonable person would think that's just ridiculous, then there's a good chance the court will think exactly the same thing.
That's right.
But I guess what we what we have done is I hope in talking about asset protection, talking about ruling from the grave in a perception point of view, a lot of times it's just that parents are giving their children the opportunity of a great structure to start with, and they can choose what they do with it as time goes on, can't they? Even with testamentary trusts and so on. I mean, they can choose to maintain it, they can choose to wind it up, but I think the intention in most cases, rather than trying to rule from the grave, is that most parents are just trying to give the greatest advantage they possibly can. Because I said to someone the other day, I mean, if you don't put a testamentary trust in your will, in your documents, you can't make it up afterwards.
No, that's correct. Yeah, you can the other way around, but if it's not in there, it's not in there. And so it's all about asset protection. That's the main purpose of those trusts. I was thinking as you were speaking, Mark, that we'll often say to clients when they're finding it difficult to decide what their wishes are going to be in their will, is to think about it as if, what do you want to happen if both of you passed away last night? So it sometimes makes you confuse yourself by thinking too far ahead in the future, and what ifs and this might happen and that might happen, and different scenarios. You can always update your will, and we always talk about it being advisable that you do every few years or after any certain significant events in your life. So to simplify it, I think the advice that we always give is to ask yourself what you would want to happen to your estate if something happened to you last night, and then that's what you should put in place now, and you can always update it.
Yeah. And, as you know, part of what I do is help people sort of look at it once every 12 months. But I mean, the reality is, it's probably every 5 years, isn't it? 5-6 years that even if nothing has changed in your life, it's worth reviewing your actual documentation, Juanita, I believe, because, things change from a tax point of view and so on, don't they? So there's other reasons why you'd want to check it every 5 years, even if you don't have any changes in regard to your assets or children or marriages or anything like that. Right. Would that be fair?
Absolutely, yeah. The law might change, the taxation law or provisions might change, and rarely does that sort of period go by where there hasn't been a significant event in one's life, whether it's marrying, remarrying, divorcing, having children, buying a property, selling a business. They're all the sorts of things that should trigger a review of your will and estate planning.
Yeah, and some people have more experience at that than others, I know. So
apparently
they need to review them more often. Juanita, look, I'm going to in a rare event. I'm going to wind this up a little early today, but I want to. I just want to say to everyone that this is our last estate and succession mastery session, and I say that with sadness. And I go back to when we started. This was really at the start of. I think it was around March last year, wasn't it? When March 2020, when COVID came in, and along with a couple of other things, I did to commence more communication via the internet and Facebook and YouTube and all that sort of stuff. I spoke to you about doing this, and I'm just going to say it was a real pleasure. I think choosing you was very wise. It's been a real pleasure. I've had lots and lots of great feedback, Juanita, in regard to your contribution. I'm just kind of here to sometimes just to be here and and certainly the feedback from people that have watched this and got value out of the half hour that we've done once every week originally and every fortnight more recently. Juanita, I just want to thank you for your contribution, your legal knowledge, contribution, and wisdom along the way. We've never failed to get through to 30 minutes in any topic.
No.
And
who would have known we could have talked so much about our wills and estates? We've been talking for over a year and a half.
Well, you know, I wish I'd actually sat down and worked out how many of these we'd done, but I mean, we've done 60, 70, or probably more of these. So
and we've used the word communication in 99% of them.
That's right. And I don't think we've actually said that word today. So
no, I don't think we did.
It's taking you 25 minutes to get the word out. But it has been. But you know what? I think the greatest thing, Juanita, has been the communication with between you and me as well. And I think from the feedback I've got, I'm not sure where it's come for you, but there's been a lot of people that have got a lot of interesting knowledge out of watching these. And I just want to thank you. You know, we're just calling time on this because I think it's probably an appropriate time to. You know, sometimes you can do things for too long. Sometimes you can do them for too short. It's like retiring from a rugby league football team, correct?
It's the end of a sporting career. No, it's been fun. Thanks, Mark. It's been a lot of fun and very enjoyable. And I'm glad to hear that people have got some value out of it.
Absolutely. So thanks, Juanita. I'm signing off for you and me for the last time, and
remember
look forward to all the good things ahead for you too. See ya.
Bye.